Check mic 1 2 3. Check mic, check.
Okay naman,
Check
Alan. We're
mic.
good.
Oh, okay.
Good, beautiful Sunday, everyone. Today is another day for us to have our HR Cafe, Usapang Buhay, Trabaho at Iba Pa. The date today is September 24. We are at episode 149. And our free training for today at the second part of our program will be about labor law. And this should be facilitated by no other than labor expert, attorney Alvin Alburo. He will be discussing about understanding management prerogative to avoid or win illegal dismissal cases. Welcome to the HR Cafe. My name is Coach Darwin Rivers, and the HR Cafe program is an online talk show program aired live every Sunday at 3 p.m. We've been doing this for over 3 years now, and we are really thankful for your continued support and trust in our program. As mentioned, my name is Coach Darwin Rivers. I'm the founder and president of the Philippines HR Group. I'm a certified life coach, public speaker, and motivational speaker. I'm also an HR consultant and currently the VP for HR of a BPO company. Of course, joining me today are your HR Cafe servers. We have Mentor Alan Cañete. Mentor Alan is a learning and development and OD practitioner. He has more than 20 years of corporate and freelance consulting experience. He's also the president and managing director of Creative Moves Outsourcing and one of the board of directors of the Philippines HR Group or PhilHRG Inc. Mentor Alan, magandang hapon, magandang linggo sa iyo. You're mute, Alan.
Magandang hapon, Coach Darwin and Coach Rona. Magandang hapon din sa mga manonood this afternoon. Isang makulimlim na hapon. Coach Darwin, thank you. Pinababata mo pala ako palagi every Sunday kasi 20 years na nakalagay dyan, inaalaska ako ng mga kabatch ko. Hoy Alan, aminin mo, mahigit 30 anyos ka na sa HR at OD. Thank you so much at nanonood ulit kayo ngayon dahil we have a very interesting topic for today. Coach Darwin, back to you.
Thank you, Mentor Allen. Of course, we have Mentor Rona Del Florentino. Mentor Rona has more than 20 years of HR practitioner experience working in different local and international companies. She's a president and CEO of Approach Social Geekers, a public speaker and HR consultant, and also an HR head of an international BPO outsourcing company currently, and also one of LinkedIn's top 100 Filipinos to follow. Mentor Rona, magandang hapon!
Yes, magandang hapon po sa ating mga viewers this Sunday afternoon. Ako, matapos po ang bug, smog at lahat na ng mga usapan itong nakaraan linggo na ito. I hope that you are all doing well at naway ma-enjoy nyo ang ating topic for this afternoon. Coach Dar?
Thank you. And of course, we also have Mentor Tina Coang, but unfortunately, Mentor Tina won't be able to join us. She is on vacation, but she will be back next week. Mentor Tina is an operations and HR leader with broad local and overseas experience. She's also a general manager of a retail company and soon to be a general manager of another fast food chain, an online content creator and blogger, well known for his blog tinaandmanil.com and also LinkedIn's top 100 Filipinos to follow. Let's start our program. Here at the HR Cafe, weekly we provide you with timely news and updates. We also impart knowledge and experience that are value-adding and beneficial to our audience. We discuss problems, issues, and challenges and provide answers and resolutions on various HR topics and even beyond HR. We also provide weekly free training, and that's at the second part of our program through our experts and seasoned guest resource speakers. And for today, we have no other than one of the labor luminaries in the Philippines. We have Attorney Alvin Alburo, who will be joining us. We also discuss new technologies, tools, and processes here in our program. So if there are any new tools, practices, or any technology that would help HR, we discuss it here in our program. At the end of the day, we would like to bridge understanding between employers and employees, and of course, provide inspiration and motivation to all our fellow Filipino audience. Now, we start our wow quote for the week for a quote come from Moliere. According from Moliere, it is not only what we do, but also what we do not do for which we are accountable. This is a very controversial and strong reminder for everyone. Let me just repeat this. It is not only what we do, but also what we do not do for which we are accountable. This is according to Moliere. We invite our audience to please make a comment at the comment section. How does this particular wow quote for the week resonates to you? What is the meaning of this quote for you? And please share it to us so that we can also share it to the community. Let's start with our mentors. Mentor Rona, at the setting of both familiar and personal. What does this quote mean to you?
May kahawig 'to na quote, eh, which if my memory serves me right, we discussed, I think, early part of last year during one of our HR cafe, when we were talking about culture. Kasi people would
Mhm.
usually say na, what you allow within your company, it becomes the culture. But
Mhm.
people oftentimes forget the things that we are silent about.
Correct.
Minsan kasi, yung mga bagay na tahimik tayo, na hindi tayo nagre-react, it also sets the tone for the culture, and it also um describes us as a person. Yung mga bagay na tahimik lang tayo. 'Di ba sabi nga nila, in order for evil to triumph, the only thing that good people have to do is to stay silent. And when we
And not
stay
do
silent,
anything.
not do anything. Stay silent and not do anything. And when we are silent and we do not do anything, it's actually us implicitly saying yes to those things na hindi naman dapat alam mo yon, nagpo-propagate or dapat na po-promote. So etong quote na to for the week, sa akin napaka-importante nito for HR people, lalong-lalo na yung part na what we do not do. More than what we do, yung what we do not do, sometimes kasi nakakalimutan natin yon, and we feel na hindi naman ako wala naman akong pakialam diyan. Hindi naman ako affected. We stay silent, we do not do anything, pero hindi natin nare-realize na other people pala are thinking na, po pwede naman pala, okay naman pala. Lalo na sa work natin as HR. Imaginein mo, di ba, na let's say you're the HR person and hinahayaan mo lang na yung let's say, kaibigan mo na mali o kung ano pa man, kasi hayaan na natin, may pinagdadaanan lang siya siguro o kung ano pa. And we make excuses for it. What we do not realize is that the things that we do and we stay silent about and we do not do anything about, it also speaks volumes about us as an HR professional. So we have to be careful. What we say, what we do not say, what we do and what we do not do, all of that will describe us as a professional and as a person. So yun yung dating sa akin. Ang ganda nitong quote na ito as a reminder for us na nasa HR profession and for those na nasa management positions, na hindi lang kayo na-judge based dun sa kung ano yung outwardly ginagawa nyo, but even on the things that you do not do anything about. It still speaks volume about you as a person. Yun sa akin. Coach Alan, ikaw po, ano po masasabi mo? Nakamute ka po.
Nakamute ka, Alan.
Yun. So, thank you for reminding me. Ang hilig ko magpa-mute, no? Pa-mute ng pa-mute. Ang ganda na explanation mo, Mentor Rona. And I have one example also, two examples, in fact. Una sa HR. Imagine an HR professional working for a company that has a policy to prevent workplace harassment. Okay? In this context, what you do as an HR practitioner, you take active steps to educate employees about company's anti-harassment policy, di ba? So, you conduct training sessions and promptly investigates kapag meron and addresses harassment complaints kapag meron. Yan yung you're doing your job responsibly. Now, what you do not do is this. Imagine if the HR practitioner is aware of a situation where an employee is being harassed by a manager, a senior manager or a supervisor, but you choose to ignore it and you choose not to take action to address the issue for some personal reasons, o takot ka siguro or whatever, no? May pabor sigurong binigay sa iyo yung mga perpetrators. This inaction can also be a point of accountability. Yan, kaya doon applicable yung yung quote, no. In this case, not taking necessary steps to prevent or stop harassment can lead to negative consequences. And these are practitioner. The HR practitioner may be held responsible for their failure to act. So in the context of HR, the quote emphasizes that the accountability is not just about the actions an HR practitioner takes or what they do, but also extends to what they not do. Now, another example in the context of ito bato-bato sa langit, wala po akong pinapataman. Pero in the context of corruption in the government, the quote by Moliere can be applied as follows. What you do, an ordinary citizen who actively participates or engages in anti-corruption efforts by reporting corrupt activities to relevant authorities, supporting or participating in peaceful protests against corruption, or staying informed, simpleng staying informed lang about issues related to government transparency and accountability, is taking a proactive stance against corruption. Pero na pinili mong manahimik, ayan, may kasabihan nga, staying silent in the midst of oppression is siding with the oppressor. If this citizen is aware of corruption within the government that remains silent, chooses not to report it, or does not participate in any efforts to combat corruption, they are still accountable. Their inaction, such as not speaking or against corruption, not voting or not supporting transparency initiatives, can indirectly perpetuate corruption in the government. Yun po ang aking take dyan. Thank you so much.
Sabi ko sa'yo, Mentor Rona, napaka-init ng quote na to. Mentor Rona, marami tayong mga audience na nagbigay ng kanilang interpretation about the quote. Would you like to share?
Pero bago ang lahat, baka masabihin tayo, political ka na naman.
Bala sila mag-isip ng ganun. Ako naman ay objective lamang at ito'y applicable sa lahat ng gobyerno sa buong bansa, sa buong mundo. Okay?
Actually, ako, personal comment lang. And this does not, may caveat na ako, this does not reflect the opinion of the whole Philippines HR group, but this is my opinion lang. I find it sad, disappointing, even that oftentimes in today's world we have to preface our sentences with wala sanang tamaan, bato-bato sa langit, sabi nga ni Mentor Alan. It saddens me that we have to do that because we know that there are some people who might interpret what we say differently. And I would understand if we are doing this, we are, the audience are people who are, sabihin na natin na hindi pa ganun ka-mature, but our audience is mostly HR. And whenever I see people, whenever we have to do that, para lang, alam mo yun, kumalma sila, I find that sad. And this is in relation to our quote for the week. I find it very sad that we have to do that kasi alam natin na merong magre-react and will take it and twist it and interpret it differently. Yun lang. Na ano lang ako. Ano talaga namin naghuhugutan. Anyway, batiin po muna natin ang ating mga nasa comment section. We have JP, I think Castro Atato. Thank you, sir, for this. I'm a graduating HRDM student and looking forward for this kind of free webinars. Ito ang ating mga future human resource professionals. I do hope that you learn a lot from our episode for today. We also have Danny Rose Marciano. Hello, HR Cafe coaches, mentors, and guests. Happy Sunday afternoon. Sabi rin ni JP, hi Sir Darwin, for me, ito yung tugma sa kasabihan na we get what we tolerate. Yes. Tulad nga ng sabi ni ni Coach Dar, ito po ay applicable sa lahat, politika, trabaho, at higit sa lahat, pag-ibig. We get the love that we deserve. Ayan. Sabi rin po ni JBC, parang kanta lang sa simbahan, walang sino man ang nabubuhay para sa sarili lamang, walang sino man ang namamatay para sa sarili lamang. Tayong lahat ay may pananagutan sa isa't isa. Happy Sunday, very, very true. Yes. Hindi ko lang po kita yung name ng ating isang Facebook user, PHRG or equal PUP, Ma'am Rona, si Sir D ata ito. Alam pag ano yun, si Sir D ata ito. Miss Matilde Belen, nasa comment section din po natin. We also have Wayne Moore Simpulan. Thank you for this very informative discussion. For the rest of our audience, please feel free to share our episode for today. Ilagay na sa inyong comment section where you're watching from para naman po shout out namin. And ito na rin po ang pagkakataon para batiin ninyo ang inyong mga friends, colleagues. Tag niyo po sila sa comment section and share the learning for today. Coach Dar?
Yes, and also inform us anong company kayo para mag-greet naman namin at ma-shout out yung
Yes.
company na pinagtatrabuhan nyo. Now, for me, this particular quote by Molière, sige, two things. In the context of the workplace, for me, I always believe that if you put a blind eye on the things that you feel bias of, it always disrupts uh, the positive culture of the company. Ang ibig ko sabihin dyan is kung meron tayong code of conduct and meron tayong policies and procedures, you need to make sure that you implement it. This is not only for HR. This is for all department leaders, department heads, frontline managers, because I've seen a lot of leaders wherein minsan may biases sila na where yung ibang employee pag nakagawa ng kasalanan, nakagawa ng mistake, halimbawa na late lang, naging tardy, naging absent, or bumaba yung performance, pinapapilan kagad, kino-coach kagad, which is actually part of the process, which is I'm very fine with it. But I've seen people also na pag close sa kanila or pag within their circle or medyo bias sila sa tao, ang nangyayari is pinapabayaan nila. They put a blind eye on all of the negative things or the infractions that those employees or those leaders are committing. I also had experience where in the management level na ang hirap i-call out pagkapareho mong manager. Di ba? Nahihirapan sila i-call out pagkapareho nilang manager kasi ano yun politics is at play whenever you're at the board meeting, whenever you're at whenever you're at Excom or Mancom. But reality is, if you need to say something and you feel that it's something that you're right and you need to make the person accountable, you need to speak it up because at the end of the day, that particular action of that team member or that manager will actually be a reflection of every one of the team, everyone in the organization. So what I'm trying to say is, please, as much as possible, we need to, sabi nga ni Mentor Ron na kanina, we need to make sure that all of our actions and inactions, pinag-iisipan natin to. Kasi pag hindi tayo nag-act sa isang bagay, ibig sabihin, you're actually showing your biases. If you do not say something, you're actually showing your own biases. So the reason why there's a code of conduct, there are policies, there are processes, is it's the Bible, it's a guidance for everyone to follow. And if it's there, then no one should be above the law. No one should be above any policies, di ba? Now, in the context of life, ako, paulit-ulit na to. Marami ng tao nagsabi na minsan may pagka-political yung tone ko. But I always believe that as an HR leader, as a people leader, there's no politics when you ask for accountability and transparency. Wala pong politika doon. That is simply a fact. And if you cannot understand why accountability, transparency, and good governance is something that needs to be normalized, then there's something wrong with you, not with me. Okay? So that's my point. And para naman sa ibang mga nanonood dito, good afternoon. Watching from Dagupan City, Pangasinan, shout out na rin po sa mga instructors ko sa Pangasinan State University, San Carlos City Campus at yung mga staff on Peso, San Carlos, yung Peso Office. Salamat po sa panonood, especially kay Sir Reynaldo and Ma'am Richelle de Guzman Barlaan. God bless. And there's also someone watching from Negros. Pasensya na po, hindi po namin makita kung ano ang pangalan ninyo. Pero maraming salamat po sa patuloy niyong pagtangkilik at patuloy niyong pagsuporta sa HR Cafe. Now, let's go to our HR question for the week. And this is, Akma. Should tenure be the basis of an employee promotion? Mentor Rona, you've been leading organizations, both international and local organizations, a lot of leaders would say that dapat pag matagal sa kumpanya, yun dapat ang unang napopromote. Is that something that should be put into policy na tenure should be the basis of promotion?
Okay, if we are talking about sole basis for promotion, then definitely hindi yan magandang practice. Kasi you will come across people, especially dun sa mga, excuse me, yung mga umattend na nung ating si HRP at yung mga uma-attend ng mga webinars ni Aprush, lagi natin sinasabi ito, na meron kayong mga empleyado na kahit na gaano katagal, hindi sila nag-gain ng panibagong competency. Kung nasan man sila, masaya na sila doon at ayaw talaga nila mag-move forward or ayaw nila ng kahit anong promotion. You will come across people like that. So, hindi magandang basehan ang tenure alone for promotion. You will also come across people na kahit na bago pa lang sila, yung kanilang learning curve, kakaiba, madali silang maka-adapt, madali silang maka-gain ng mga bagong competency. And it would be unfair to them na huli silang mapopromote just because late lang sila naging part ng company kahit na sila yung may pinakamalaking ambag. When you do that, at nagiging basis nyo lang is yung tenure solely, ang mangyayari ngayon dyan, anyone who's new to the company, na performer talaga, makikita ninyo na babagsak yung kanilang performance. Kasi makikita nila na tenure lang pala. So, minimum effort lang ako kasi basta umabot na ako ng let's say ilang years, automatic naman yun mapopromote ako. Sets the wrong
Demoralize sila, no?
Demoralize yun. Kasi parang walang pag-asa na ma-promote.
Diba? Oo. Kumbaga, intayin ko na lang na marating ko yung tenure na yun para ma-promote ako, which is a very, very bad practice. Now, we are not saying that it should not totally be taken into consideration. When we speak of performance management, especially when it comes to promotion, it's impacted by a number of factors. Your performance, and if you have somebody else who has the same level of performance, you also take into consideration the tenure. And when we say tenure, it doesn't always have to mean na pinakamatagal. It could also mean na pinakamabilis na natuto. Kung sino yung may pinakamaiksi pero ang taas kagad ng productivity, it can also be used as a factor for promoting someone. Kasi if it takes you years before you get a certain competency, that means meron pa tayong kailangan hasain on how you are able to adapt to things. So it's a mix of a number of factors. Depende sa kung anong importante sa organization. At the end of the day, it's always about the performance. Ano ba yung impacting? Yung talagang matindi ang impact doon sa performance nung company. Aling performance ni employee, aling factor na meron si employee, ang talagang matindi ang impact sa company. You use that now to determine kung sino ba talaga yung maaaring i-promote within the organization. Coach Alan, Coach Mentor. Coach Alan, ikaw po, ano pong masasabi mo?
Ang ganda nung sinabi mo. Kasi, tingnan mo there are two sides of a coin. One group of yung mga nagpo-promote na mga superiors who are quite traditional in their method, meron silang pinupunto. Their argument in favor of using tenure is dalawa, experience and knowledge. Another one is employee loyalty. On the other side of the coin, yun namang ang argument is they're against tenure kasi ang kanilang punto, promotion should be based on performance, fairness and equality, and productivity and innovation na pinapakita nung potential leader, no? So, dalawang schools of thought. The group that favors tenure as a basis for promotion, no? Ang paningin kasi nila, longer serving employees often have more experience and knowledge about the company, about its operations, about its customers. Kaya promoting them can be seen as a way to reward this experience and ensure that their knowledge benefits the organization, the company. Another one, yung binanggit ko kanina, employee loyalty. So, recognizing and promoting employees based on their years of experience can help build employee loyalty and job security, lalo na ngayon na parang hindi na to relevant sa maraming kabataan, nire-reward dito ng employers to show them that loyalty matters. On the other side of the coin, I mentioned three: performance matters para sa kanila, employee, yung tatawag na fairness and equality principle, and yung productivity and innovation. Itong school of thought na to believes that tenure alone doesn't necessarily reflect an employee's current performance or capabilities. May mga employees na 10 years, 20, 15 years, 20 years sa company, pero sabi nga ni Ma'am Rona, ang baba pa rin ng learning, mabagal yung learning curve. Tapos yung productivity, yung contribution, wala masyadong significance sa company compared to somebody na bago lang sa company, very productive, very innovative, mataas, galing ang performance. Yun yung sana'y tinitingnan according to the other side of the coin, no? And plus pa yung principle of fairness and equality, hindi importante sa grupong ito na tingnan mo lang yung haba ng panahon ng pagsisilbi sa kumpanya. Tingnan mo talaga yung kanyang competencies, yung kanyang progress, yung kanyang contribution. May marami akong kilala, mga matatagal na sa companies, pero talagang para sa kanila, nagiging entitled pa nga ito, no? Para sa kanila, yung kanilang loyalty, ang kanilang experience, na hindi naman masyado nagagamit ng organization yung experience, they want to be honored for it. Kaya lang nga, they feel jealous of the young ones who are more competent than them. Kaya nagkakaroon ng problema nauwi sa generation gap. Another one is productivity and innovation. I mentioned this already. The young generation is known to be very innovative. Mayaman sila sa magandang ideas, which sometimes the older guys are not interested in or quite fearful, lalo na sa technology. Kaya nagkakaroon ng problema dyan. No? So overall, ang tingin ko dyan, there should be a mixture or balance. We strike a balance between tenure and performance when making promotion decisions. They may use a combination of factors including job performance, skills, qualification, experience to determine promotions. Siguro yung loyalty may factor, may weight din yun among the factors, and this approach aims to reward both long-term commitment and current contribution to the organization. That's my take. Coach Darwin, you are muted yata. Ikaw rin, papamute ka.
Sorry. Sabi ko salamat, Mentor Allen, Mentor Rona. Siguro, before I answer this particular question for the week, I'll share muna kung ano yung ginagawa namin. I always believe that whenever you are promoting someone, you need to look into two things. May aspiration ba yung tao ma-promote? Kasi hindi naman lahat ng tao gusto ma-promote eh. Meron mga tao na fearful sa new responsibility. May mga tao na okay lang sa kanilang hindi ma-promote kasi sa kanila mas malaki pa yung kikitain nila kesa sa mga leaders nila kasi sila merong overtime, night shift, merong may mga bonuses na wala yung ibang mga leaders. Diba? Ano yung aspiration? Ano yung mas importante dun sa tao? Second is, of course, yung qualification. Ano yung mga qualification na magiging basehan mo para i-promote yung tao. Halimbawa, pareho silang may aspiration pero hindi lang ina-aspire na maging manager or supervisor. Now, ang titignan mo na sunod is yung qualification, kung paano mo sila i-evaluate. And yung sinasabi ni Mentor Rona sa kanang Mentor Alan na may mga factors ka talagang dapat tignan. And tenure is only one. Sa amin kasi pag sinabing tenure factor, anyone na naka 1 year na sa company is automatically considered to be part of the promotion. Kasi yung iba ang hirap naman mag-promote pag hindi pa tapos sa probationary period, 'di ba? Although nangyayari talaga 'yan. Minsan pag kailangan niyo ng tao and wala kayong makuhang external, you will really look into your probationary employees. But what I'm trying to say is mas maganda sana kung bago kayo mag-promote, tignan niyo muna yung mga regular employees nyo. Now, aside from tenure, we also need to check on sabi nga nila is performance. Ano yung performance ng tao? Second would be behavior. Meron bang mga write-ups or mga NTEs tong employee na to? Baka mamaya ipopromote ba siya pero hindi naman pala siya siya pa mismo ang kumbaga siya pa mismo ang may mga NTEs, siya pa mismo yung may record sa kumpanya. But how would you ask someone to champion your code of conduct if the person you're promoting doesn't even believe or doesn't even implement the policies and code of conduct of the company or doesn't support the policy of the company? Next would be yung quality of leadership, yung soft skills niya. As a leader kasi kailangan kung magpo-promote ka, may soft skills ba siya to become a manager or a leader? Yung mga bagay na yun kasi natuturo. Pero may mga bagay naman na sa simula pa lang makikita mo na very meek yung tao, ayaw niya yung introvert siya, ayaw niya na may hinahawakang team or whatnot. You really have to consider that. And that's the reason why in all of my previous company, we always practice 9-box. Yung 9-box system of making a promotion. Kasi sa 9-box system, makikita mo kagad ano yung aspiration ng tao, saan siya magaling. Magaling lang ba siya sa a certain aspect of work or meron siyang mga characteristics na pwede siyang magaling sa ibang department or sa ibang teams or ano pa yung mga soft skills niya na pwedeng mapakinabangan at masabi mo talaga na ready na for promotion yung tao. And of course, undergoing toll gate, ito yung inputs ng mga leaders about the person. So for me, tenure should not be solely the basis of promotion. It will always be a lot of factors, but at the end of the day, look into why are you promoting the person? Are you promoting the person because the person already has matured to become a leader, or you're just promoting the person because there's a business need? Kasi kung business need yan, I would rather na put the person, not promote the person first, but put the person into a leadership training program. Kumbaga hindi mo kagad siya ilalagay as a leader. Meron siyang mga training programs na kailangan matapos at kailangan niyang ma-evaluate para maging leader talaga siya, maging manager talaga siya. Ito yung mga tinatawag natin Metrona, di ba, na POCs. Ano ba yung ibang term dyan? POCs,
In charge.
in charge.
Lalagyan
Yan,
ng in charge. Oo.
in charge, yan. Or management trainee program, di ba? Yung mga ganon. So, hindi mo kagad binibigay yung title kasi pag binigay mo na yung title, kasama na yung benefits. Di ba? Mahirap na mabawi yon. Hindi imposible, pero mahirap mabawi. Pero pag in-undergo mo siya ng management training program or evaluation or leadership competency program, minomold mo siya to be ready for the role. So yon, that's our take for HR question for the week. Now, updates coming from DOLE, the Office of the President issued Memorandum Circular number 32 for observance of the National Family Week. Malacanang issued on Thursday, Memorandum Circular 32, suspending work po in government offices under the executive branch. So pag executive branch, basically lahat ng under ng Office of the President. Kasama na dyan yung SSS, Pag-ibig, lahat ng mga government agencies except Congress and Judiciary. Diba? So almost lahat ng departments ng government ay hanggang 3 o'clock lang po sila. Sa darating na September 25, Monday, ito po ay yung connection sa kanilang observations of the Family Week. Paalala lang po, para lang po ito sa mga public agencies or government agencies under the government offices under executive branch. So, kasama na rin po yung mga local government nyo kasi basically, local government except under those under Congress and Judiciary, hanggang 3 o'clock lang po sila. Hindi po kasama ang private sector, ini-encourage lang po. So nasa sa inyo po 'yon kung i-practice ito. Pero po sa government, hanggang 3 o'clock lang po sila every Monday, last Monday of the month, starting this year, September 25. So that's update coming from DOLE. And another update, nako, pinapaalala lang po namin sa inyo, napakadaming discussion about this. Huwag po kayo makakalimot para po sa mga employers sa taga Central Visayas. Effective po next week, tama, October 1, 2023, ang pagtaas po ng minimum wage sa Central Visayas. Ito ay under wage order number RO 7-24, which provides an increase of 33 pesos in Region 7 or Central Visayas. So, ang new daily minimum wage po in Class A to C areas range from 420 to 468 for non-agriculture establishments and 415 to 458 for agriculture and non-agriculture establishments with less than 10 workers. Ito po ay effective October 1, 2023. So we are encouraging employers to ensure that you implement this particular wage order, lalo-lalo na po kung kayo po ay nasa Central Visayas. At tulad nga na sinabi namin last time, sunod-sunod na po yan. Nag-start yan sa NCR, tapos sumunod na Calabarzon, ngayon ang Central Visayas. Asahan na po natin na sa mga darating na linggo at buwan, magkakaroon po ng increase ng minimum wage in different regions. Tulad po na nangyari last year, na sunod-sunod po ang increase ng minimum wage. Which is actually magandang balita para sa mga employees, para sa mga employers. Ito po ay isang pagpapaalala na kailangan natin tignan kung paano natin mapupunuan itong particular na batas na ito through our funding in our companies. Okay? So that's it for me. And advisory from SSS, Samantha Rona.
Yes, pinapaalala po ng SSS, yung pong kanilang OMDCR or yung Online Member Data Change Request sa my.sss po is currently unavailable dahil sila po ay nag-a-apply ng enhancement. So paalalahanan nyo po yung inyong mga miyembro, yung inyong mga empleyado in case na gusto po nilang magkaroon ng mga simple changes sa kanilang SSS account or SSS information. Hindi po nila magagawa yan right now dahil unavailable po yung module na yon, yung system na yon sa my.sss, hindi po nila mababago ang kanilang mga details. Antayin nyo na lang po na matapos yung enhancement na ginagawa ng SSS. This is actually a good news for us kasi yung OMDCR, yun yung pinakamadaling way para baguhin yung mga very, very small details lang naman dun sa inyo pong SSS record. So antayin nyo na lang po na mag-announce po ang SSS na okay na sila with the enhancements. We are actually looking forward to this kasi hopefully, pati yung ibang mga kind of major adjustments doon sa information details niyo ay maaari nang gawin online. Ayan po. At pinapaalalahanan din po ni SSS kung kayo po ay merong SSS ID. Naku, magandang balita po kung SSS member kayo na may SSS ID at meron din po kayong SM Advantage Card or SMAC. Meron po kayo, maaari po kayong makasave ng up to 300 pesos pag kayo po ay nag-shopping sa SM Store. Basta't i-present nyo lang po ang inyong SSS ID along with your SMAC. Ito po ay available from September 18. Ako, tapos na pala ito. September 18 to 22. Hindi ko sure, alam ko may extension ata ito, pero i-check nyo na lang po. So, huwag nyo pong kakalimutan yung inyo pong SMAC at yung inyong SSS ID. Kung wala pa pong SSS ID, unfortunately, alam ko ang SSS ay hindi na nagpa-process ng SSS ID. UMID na po ang pinaprocess nila right now. So, pumunta na po kayo sa pinakamalapit na SSS para makakuha ng UMID. Now, be careful lang po ha, kasi alam ko ay merong mga branches ng SSS ang currently down yung system nila para po sa UMID. So, i-check nyo po kung alin pong mga branches ang pwede po kayo mag-apply ng UMID. Pag hindi pa po available sa area nyo or down sa area nyo, antayin nyo po kung kailan po pwede ulit magpakuha ng UMID. Punta kagad kayo kasi napakalaking tulong po na meron kayong UMID. Kung kayo naman po ay tulad ko, na lumang SSS ID pa ang meron, huwag pong mag-alala, yan po ay ino-honor pa rin naman po ng SSS. Okay.
Anong namang SID? Yung papel pa ba yan? Papel
ay, hindi naman papel. Huwag naman. Pag papel pa po kayo, malamang ay naka-final benefit na po kayo sa mga sandaling ito. May digitized ID naman po ang SSS. Ito po yung magnetic strip pa yung nasa likod. Yan, medyo umabot naman tayo doon sa ID na yun. pag nakapapel pa po yung ID ninyo, malamang final benefit na pong ini-enjoy ninyo sa mga sandaling ito.
Binaparinggan niyo ba ako?
Ay, hindi, Alan, inassume namin na umabot ka naman sa ID. Ayan po, pinapaalala din po ng Pag-ibig dahil nga po doon sa announcement tungkol po doon sa early out sa September 25, ang Pag-ibig din po ay magkasasara po sila ng maaga hanggang 3 p.m. lang po sila on Monday. So pag meron po kayong mga kailangan na transactions, maaari nyo pong gawin yan doon po sa inyong virtual Pag-ibig app. Kung may mga concerns po, pwede po kayong tumawag sa 8 Pag-ibig or email them at contact us at pag-ibigfund.gov.ph or i-chat nyo po sila sa kanilang website www.pag-ibigfund.gov.ph dahil open po yung mga channels na yan sa September 25. Yung opisina po ay sarado pero yung kanilang mga contact channels ay available po yan sa September 25. Full day po silang nandoon. Ayan po. At syempre pa, kung kayo po ay merong Pag-ibig ID, gamitin natin yan, gasgasin natin yan. Gamitin po natin para makakuha po tayo ng 10% discount sa Figaro, sa Angel's Pizza at sa Tienma. So kung kayo po ay nagugutom, punta na po kayo dyan, gamitin po ang inyong SSS, ang inyong Pag-ibig ID, loyalty card or loyalty plus card, pareho nyo pong po pwedeng gamitin yan. Mahaba po ang listahan ng mga available na discounts pag kayo po ay merong loyalty card and loyalty plus card. Kung wala pa po kayo, again, punta na kagad sa Pag-ibig. Mabilis lang pong makakuha ng loyalty plus card. Promise. Kung gusto nyo po ng super bilis talaga, punta po kayo doon sa mga branches ng Pag-ibig. Kasi kahit saan po ito ay pwede kayo mag-apply. Punta po kayo sa branches ng Pag-ibig na medyo hindi pa gano'n ka-famous, kilala, or walang masyadong traffic. Kasi napakabilis po ng application sa kanila. Within minutes po, ako nung nag-apply ako, inabot lang ata ako ng 30 minutes, nakuha ko na kagad. Yung card ko, napakonsolidate ko pa yung aking mga information. So, wala akong masasabi. Isa sa pinakamamahal nating agents ng Pag-ibig. No? Napaka-efficient nila.
Hindi ko na maintindihan, Mentor Ron, is pareho lang naman under government ang SSS, Pag-ibig, sa PhilHealth. Pero dun sa tatlo, si Pag-ibig talaga yung pinaka-efficient. No?
Yes.
Kasi Pag-ibig yung mabilis umaksyon. Sana maging benchmark ang Pag-ibig kay SSS sa PhilHealth.
Pagdating sa efficiency ng proseso, napakabilis ng Pag-ibig. Siguro hindi lang efficient sa kanila yung centralization ng kanilang information kasi kailangan mo pa ipa-consolidate. Pero they're already doing something about it. Kaya nga nagkakaroon na tayo noong ESRS at saka yung mga virtual Pag-ibig kasi gusto na nila i-consolidate. Pag consolidation ng information, ang magaling dyan, PhilHealth. Oo, pagdating sa SSS, maraming benefits. Ano masasabi ko? Pero hindi, at least, di ba, nag-aano naman sila. Nakikita naman natin ngayon yung changes na nangyayari dito sa tatlong government agency na to.
Agree. Compared the past few years. Mentor Alan, for PhilHealth, what's the news about?
Yung Pag-ibig talagang love yan ng maraming tao. Pag-ibig talaga siya ng maraming tao, ng mga Pilipino. At speaking of love, ito pong sunod nating agency, itong PhilHealth. Love ito ng maraming taong nangailangan ng tulong, lalong-lalo na during talagang dire need, no? During kagipitan. Kagaya ngayon, sagot ng PhilHealth ang pag-anggamutan para sa mga individual, kadalasan to mga bata, mayroong cerebral palsy. 9,500 po ang budget ng inilalaan ng ahensyang ito para sa mga kabataan, mga baby, usually mga toddlers and neonate, meron na symptoms ng cerebral palsy. Ito in celebration of the 20th Cerebral Palsy Awareness and Protection Week na ginanap between September 16 and 22. Pero hanggang ngayon ito ay magagamit pa naman. So, pangalawa, sinabi rin ng PhilHealth na naku po, mag-iingat po kayo, no? Dahil may mga taong kumakalat-kalat ngayon at ginagamit ang PhilHealth para sa kanilang mga modus operandi. Hindi po authorized ng PhilHealth ang sino man na nag-aalok ng assistance para sa PhilHealth ID o Member Data Record, MDR, nang may bayad. Ang ID at MDR ay libre. Okay? Bukas po ang tanggapan ng PhilHealth sa sino mang nangangailangan ng kanilang serbisyo. Kung hindi kayo makakapunta, mag-online na lang po. Meron silang online transaction at ito'y nandyan po naka-display sa ating screen ngayon. I-click nyo lang yan pag kayo'y pumunta sa website nila at inyo pong makukuha ang mga detalye. Or call back channel 0917-898-7442 para sa karagdagang detalye. Or bisitahin po ang kanilang website sa www.philhealth.gov.ph at yung kanilang mga social media accounts para sa karagdagang detalye. So mag-iingat, wag ho kayong paluloko sa mga nagmomodus na ito. Ang sunod na gusto kong i-announce, tayo pong, may mga kasamaan tayo mga HR practitioners na laging umaangal sang katutak na stress ang kanilang dinaranas sa kanilang trabaho. At matapos sila makinig ng mga problema ng mga empleyado bilang HR, sino naman daw ang makikinig sa kanila? Meron po. Sino ang HR ng HR? Narito na ang tinatawag nating partnership ng Infinite Care at saka ng PHRG. Ang Infinite Care ay isang grupo na nagbibigay ng serbisyong ito para sa mga HR practitioners na nangangailangan ng pag-aruga at konting mental health care sa kanilang naranasang difficulties. This unique partnership, a unique partnership to support the well-being of the professionals who look after the nation's employees. Okay, ano ba makuha natin sa pagiging member ng app na ito? Ito isang app, no, na pwede niyong ma-access through your mobile phone, no? Ang partnership na ito will provide Infinite Care's mental health support platform to PHRG members, giving
For
them
free.
access, yes, and for free, giving you or us access to personalized care tools and resources, a chat helpline, and virtual sessions with licensed counselors, psychologists, and coaches. Kaya kung kayo'y nalalongkot at wala makausap at kayo'y natutolero na ba, eto meron po tayong matatawagan para meron namang nakikinig sa ating mga bigat ng damdamin. So, take advantage of this. Libre lang ang pagiging membro. Coach Darwin, how can they access this?
Oh, you just have to download the Infinite Care app either in Google Store or Apple Store, and then pag-download nyo na po, mag-sign up po kayo dun sa Infinite app na application, and ang gagamitin nyo pong password ay PhilHRG-IC. Pag nagamit nyo na po yun, kayo po ay mabibigyan ng free access sa lahat po ng services ng Infinite
Yun.
Care sa application na yon. So,
Alright.
yun. And then, of
Next.
course, let me,
sige,
me
sir.
be the one to introduce this. Nako,
Go ahead.
naanyayahan namin po kayong lahat, sa lahat po ng masugid namin taga-subaybay, taga-panood, at for the past years sumusuporta sa HR Cafe. Kami po ay magkakaroon po ng napakalaking event. Ito po ay mangyayari sa darating na October 13. Friday po yan. Ito po ang Philippines HR Group HR Summit 2023. Over the past few years, nagkaroon na po ng summit. The HR Summit is actually an annual event of the Philippines HR Group. But during the pandemic, 2020, 2021, 2022, natigil po ang HR Summit because of the pandemic. And we've decided po to relaunch it this coming year. That's the reason why we'll be having our Philippines HR Group HR Summit 2023. Ito po ay magaganap sa Sheraton Manila Hotel. Ulitin ko lang po, ito po ay sa Grand Ballroom ng Sheraton Manila Hotel. Ang Sheraton Manila Hotel po ay nasa Andrews Avenue sa Pasay. Tapat po siya ng NAIA 3, doon po sa may compound ng Resorts World Complex. So, makita-kita po tayo. Ang agenda for the Philippines HR Group HR Summit ay ang P3s. Ito po ang Paradigms and Perspective on People's Strategy. At napakarami po tayo mga speakers. Nasa 20 plus po ang speakers natin. At kasama po sa mga speakers natin ay walang iba, ang isa sa ating mga mentors dito sa HR Cafe, sa mentors Ronald Del Florentino. At of course, makikita niyo po kami dyan nila Mentor Alan at ni Mentor Tina, because Mentor Tina will be hosting. Me and Alan will be at the back end supporting the event. So magkita-kita po tayo sa October 13. Sa lahat po na hindi pa po nakakapag-register, ang registration link po ay nasa Facebook page, sa announcement ng Facebook page ng Philippines HR Group, or you can scan po itong QR code na makikita niyo sa poster namin dito sa screen. I-scan nyo lang po yan at dadalhin po kayo sa registration link at sa payment link for the Philippines HR Group HR Summit. Napakamura lang po ng HR Summit kasi over the past years, palagi po namin sinasabi to. The Philippines HR Group is a non-profit, non-stock organization. Kami lang po ang bibigay sa inyo talaga ng very cost-effective kasi hindi po for profit ang mga events namin. 3,999 po per pax. Ito po ang early bird rate. Hanggang September 30 po, pwede kayo magbayad for the early bird rate. Beyond September 30, it's already our regular rate of 4,499. Pero napakamura po yan compared po sa mga kasabayan naming HR conferences. Sila po ay nasa 8,000 to 12,000. Tayo po nasa 5-star hotel, buffet, more than 20 international speakers at for a fraction of a price, it's only 3,999. So mag-register na po kayo and make sure to save your seats at the coming HR Summit. Also, prior to bago po ang HR Summit, meron pong World HR Summit. Ito po ay mangyayari on October 5 to 6. 2 araw po ito sa Marriott Hotel. Ang normal cost po ng World HR Summit is $399 per pax kasi po ito po ay sa Grand Ballroom ng Marriott. 2 days po siya, 2 whole days. Pero kung member po kayo ng Philippines HR Group at dahil po ang Philippines HR Group ay supporting partner ng World HR Summit at kayo po ay a-attend ng Philippines HR Group Summit sa October 13, yung first 100 po na nag-register at nagbayad para sa Philippines HR Group Summit ay makakareceive po ng complimentary pass para sa World HR Summit. So, for the price of only 3,999, makaka-attend na po kayo ng Philippines HR Group Summit on October 13 at may complimentary pa po kayong 2 days sa World HR Summit. So, mag-register na po. Magkita-kita po tayo. Marami pong speaker, taga-PHRG, ang speaker sa World HR Summit. Ako po ay magtotalk. Sa second day na po pala ako magtotalk. So, magkita-kita po tayo sa October 6, dyan po sa Marriott Hotel for the World HR Summit. At, nung nakaraang Biyernes ba o Sabado to, Ron, ano nangyari? Sa PSTD po, sa annual conference ng PSTD ay tayo po ang ating pong programa na HR Cafe ay ginawaran bilang isang finalist sa Gawad Maestro Award for the most outstanding learning po yan. So, Learning and Development Organization program for NGO. So, maraming salamat po. 3 taon namin na po itong ginagawa itong HR Cafe under the Philippines HR Group. At kami po ay lubos pong nagpapasalamat sa pagkilala na iginawad sa amin ng PSTD para po maging finalist sa Gawad Maestro Award for Most Outstanding Learning and Development Organization. Next year po, we're aiming for the Ultimate Gawad Maestro Award, and hopefully you'll be there to support us. Now, for any questions, please post it at the main page of the Philippines HR Group. And also, we encourage you to please join. If you're not yet a member of the Philippines HR Group, please join us at the Philippines HR Group in Facebook page. We have almost 310,000 in Facebook who are members of the Philippines HR Group. While in LinkedIn, we have a growing community of 35,000 plus members of the Philippines HR Group in LinkedIn. So, makikita nyo po lahat ng mga activities and announcement namin, pinopost po namin. At lalo na sa Facebook page ng Philippines HR Group, doon po marami talaga kayo matututunan kasi marami pong sumasagot ng iba't ibang katanungan patungkol po sa HR at people leaders, issues, and kung ano-ano pa. So please join us at the Philippines HR Group. Now we're going to the second part of our program. Ang ating pong speaker ay walang iba. Sabi ko nga po kanina, si Atty. Alvin Alburo. Atty. Alvin is actually someone na I've worked with. Kinuha ko po siyang corporate partner. Yung firm po niya, na Alburo Law, ay kinuha kong corporate partner way back in one of my previous companies. And he has graced our program a couple of times already, and we've actually invited him to be with us today to discuss another hot topic, and this is about Magic Prerogative. I'll give Mentor Rona the floor to properly introduce Atty. Alvin Alburo.
Bago ko i-introduce si Atty. Alvin, naalala ko lang yung joke ni Mentor Alan na ikaw ba'y nalolongkot? Mentor, Coach Alan, tayo na lang nakakaalam ng commercial na yun. hindi na alam ng mga Gen Z yun.
Alam ba?
Hindi sila makarelate.
Nasi-shock siguro sila, no?
Oo. Iniisip nila, saan kaya niya nakuha yun? Ba't kaya ganun ang pagkakasabi? Hindi nila alam na commercial yan dati. Tayo na lang ang nakakaalam.
Philippine Advertising Congress. Gumamit.
Diyos ko. Napaghahalata tayo, Mentor Alan. Anyways, so itong hapon po ito, I am very honored to introduce our speaker for today. Attorney Alvin Liao Alburo is a practicing lawyer and managing partner of Alburo and Associates Law Office, a law firm specializing in business law and labor law. Attorney Alburo is a senior lecturer in the School of Labor and Industrial Relations of the University of the Philippines, Diliman, or UP Soler. Side comment lang po, open na po ang registration para po sa second semester sa UP Soler. So pag interested po kayo na mag-specialize in industrial relations, na kung maganda pong mag-enroll, malamang po ay magiging isa sa mga lecturer niyo po si Attorney Alburo. Attorney Alburo's areas of practice include labor relations law, corporate law, and intellectual property law, providing legal services to various industries. He is a member of the Technical Working Group of the Employee Confederation of the Philippines, or ECOP. He has served as the head of the Human Resource and Legal Services Department of Crown Asia Chemicals Corporation, a publicly listed company. He was also a former legal officer or junior assistant manager in the Legal Department of Federal Land Inc., then member of the Metro Bank Group, and now of GT Capital Holdings. Attorney Alburo is a resource person in the Workers Institute of Labor Laws, or WIL, in the School of Labor and Industrial Relations of the University of the Philippines, Diliman. He holds a Master of Laws degree from the San Beda University Graduate School of Law. Without further ado, let me welcome to our stage Attorney Alvin Alburo. Attorney, kumusta po?
Good afternoon po.
Good afternoon, Atty. Alvin Alburo.
Thank you. Yes, I can hear all of you. Can
Medyo,
you hear me?
sound nyo po medyo hindi namin kayo maintindihan, sir.
Oo.
Medyo garbled.
Medyo nag-feedback po.
Medyo nag-feedback po kasi. Hindi ko po alam kung bakit nag-feedback. Ganyan po talaga pag live. Pero let's see.
Murphy's
Can you hear
Law.
me
Ayan,
okay na po.
okay na po.
Attorney Alvin, how are you today?
I'm fine, and thank you very much for having me, Coach Darwin.
Okay po. So,
Uh,
we'll give you the floor po, Attorney Alvin. And I know you mentioned earlier that you're more comfortable in discussing your topic about understanding management prerogative to avoid or win in an illegal dismissal case. Sabi niyo po, mas maganda na interactive at kahit na wala kayong presentation, but you will be discussing this to our audience. We have more than 50 audience ngayon na watching us live, and I'm sure hundreds more will be watching our program on the replay. So we'll be giving you the floor, sir.
okay.
Ayan po. Reminders lang po sa audience po natin, if meron po kayo mga question for Attorney Alburo, lagay lang po ninyo sa comment section para ma-address po natin yan. Attorney, the floor is yours po.
Okay. So, aside from Coach Darwin, I would like also to recognize the presence of Mentor Rona and Mentor Alan. So, good afternoon, no, everyone. If you have questions, uh, may I ask for your indulgence to reserve your questions at the end of my talk? Why? Because it's possible that the answer to your question can be found in the course of my talk, okay, so that we can maximize our time. Nevertheless, I will answer all your questions, okay, at the end of my talk. So just some, no, legal preliminaries. Okay. Article 4 of the Labor Code of the Philippines is entitled Construction in Favor of Labor. Okay? So there you can find the provision stating that all doubts, no, in the implementation and interpretation of the labor code, as well as its implementing rules and regulations, shall be resolved in favor of labor. Okay? We should always harmonize the labor code of the Philippines with the civil code of the Philippines. And why is that? Labor law with civil law? Because many do not know, by the way, that labor law is a branch of civil law. Now, under Article 702 of the Civil Code of the Philippines, the law is very clear. Law is very clear in saying that not only labor legislations are to be interpreted in favor of labor if there are doubts, but also labor contracts. Okay? So see, Article 4 talks about interpreting the labor code, no, if there are doubts, as well as its implementing rules and regulations in favor of the employee. In Article 702 of the Civil Code of the Philippines, it's more specific in saying not only laws, but included are labor contracts. Doubts in labor contracts are to be interpreted in favor of labor or in favor of the employees. So, if you are not happy with that kind of pronouncements of the law, no, it is therefore important, no, that your policies, your rules are crystal clear. Why? Because if your rules uh, permit doubts, these doubts shall be resolved in favor of labor. Also, if employment contracts that you have drafted, you are on the employer side, no, give room for doubts, those doubts shall be resolved in favor of the employee. Don't forget that. Now, on management prerogatives, okay, we cannot divorce from management prerogatives illegal dismissal. You know, illegal dismissal, my friends, has two forms. You have actual and you have constructive. When you say actual illegal dismissal, oh, you told the employee, I do not want your presence anymore in our company. Today is your last day of work. So tomorrow, don't report for work anymore. You are fired. Friends, that is actual dismissal. One of the two forms of illegal dismissal. So question is, what's the other form? The other form is known as constructive dismissal. Now, what is constructive dismissal? In essence, constructive dismissal is when you make the life of your employee so difficult, so miserable, that the employee has no other choice but to quit his employment in order to get out of the hell that you created for him or for her. That's constructive dismissal. Now, it is on that particular matter that we shall deal with management prerogative. Again, because when we talk about constructive dismissal, which is a form of illegal dismissal, no? When you make the life of your employee so difficult, so miserable, that the employee has no more other choice but to quit his employment, that is illegal dismissal in the form of constructive dismissal. Therefore, it is a must, no, for employers. It is a must for HR practitioners to understand management prerogative. Okay? Now, what is management prerogative? Okay? So, if we are going to examine the plethora of cases decided by the Supreme Court, management prerogative is defined as the authority of the employer to run his business in whatever way he wants to do it. That's management prerogative. But aside from that, management prerogative is also a collection of rights of the employer pertaining to the employees. Okay? So, I will provide to you some management, some rights, no, under management prerogative. This list that I'm going to provide to you, my friends, is not exhaustive. Okay? So there can be other rights, no, under management prerogative. I just made sure, my friends, that we are going to tackle this afternoon those rights that you encounter almost every day in your work as HR practitioners. Okay. Now, what are these various rights under management prerogative? We have the right to prescribe rules, right to hire, right to discipline, right to transfer, right to set work schedule, right to reorganize business, and even the employer's right with respect to post-employment restrictions. Okay? So we're going to discuss the salient points, okay, on this of these topics under management prerogative. Okay. Let's start with the right to prescribe rules. My friends, management can prescribe any rule. Management can come up with any policy that it wants for its business, for as long as these rules, these policies do not contravene the law. Okay? Or existing contracts like CBA, employment contract, and another limitation to the right to prescribe rules of the management by the management is that these rules must be attended with justice and fair play. Now, let us have some examples under the right to prescribe rules. Okay? So, by the way, my friends, this lecture is not exhaustive. I'll just give you the salient points because I only have 45 minutes with you. Let's say in the employment contract of Mr. X, no, is stated therein, among other provisions thereof, that Mr. X is exempt from doing time in and time out. Okay? Now, for example, Mr. X has already been in your company, let's say, for around 1 year, and you have a change of heart. And then you said, Mr. X, you need to do time in and time out is starting on Monday. Oh. And Mr. X said, and what is your basis, boss, of telling me so? And what did you say to Mr. X? You said, my basis is management prerogative. I have the right. No, I have the right to prescribe rules. And so I am prescribing rules now that you need to do time in and time out. Oh, and what will happen now? No, the employee doesn't want to obey. Under these circumstances, my friends, note that management prerogative will not prevail over the choice of Mr. X not to obey the instruction of the management to do time in and time out. Why? Because management cannot unilaterally change the contract of employment signed by the company and Mr. X. You see? That is an example, no? Wherein, very clearly, there is a right that falls under management prerogative. Nevertheless, the right of the employee prevails because management prerogative is subject to limitations. And these limitations are provided for by law, by contracts, like employment contract, like CBA. Management prerogative is also subject to the requirement of fair play and justice. Now, another example, bonuses. Oh, yes, management has the right, no, to ordain, no, or have rules, no, pertaining to giving of bonuses. As a general rule, my friends, if, for example, John, okay, went to your office, you are the HR head, and John is demanding, no, where is my bonus? My other workmates received theirs. How about my own bonus? Oh, Under those circumstances, take note, my friends, that the general rule is there is no right for the employee to demand, no, for bonus. Bonus is within the province of management prerogative. However, my friends, however, if and when you have prescribed certain qualifications, certain standards, so that an employee may qualify for bonus, if, for example, John has met all those qualifications, all those standards that you have set forth for entitlement of bonus, then in which case, no, you are duty bound to release it to him. Okay, now, so from right to prescribe rules, let's go to the right to hire. It is management prerogative to set standards, no, insofar as hiring is concerned. Nevertheless, my friends, please take note that we have existing laws that prohibit discrimination insofar as hiring is concerned. Okay? For instance, employers cannot discriminate on the basis of sex, gender, or even physical disability, among others. That list that I just gave you is not exhaustive. There can be others. The point is, again, as a general rule, management cannot discriminate insofar as hiring is concerned on the basis of sex, gender, even on the basis of physical disability. Now, the question is this. When we talk about the right to hire, and insofar as the rule against discrimination is concerned, the question is this particular rule absolute? As I said earlier on, it's just a general rule, meaning it admits of exception. Okay? So, what is the exception? The exception has been provided by the Supreme Court, and it is called bona fide occupational qualification, or BFOQ. In essence, according to the Supreme Court, management may prescribe what? May prescribe certain standards, no? Certain standards that enforcing these standards, regardless of the fact that it would amount, no, to discrimination, it may be considered as valid because it is necessary for the business. And the purpose for which these standards have been set forth cannot be achieved by any other means. So in other words, in order to achieve the purpose of the management, it is a must that these standards that would seemingly, no, result to discrimination must be complied with in order to achieve the purpose. And there is no other way to achieve the purpose other than meeting these standards. BFOQ, bona fide occupational qualification. Case in point, Iraswege versus Philippine Airlines. So very briefly, my friends, Iraswege was a flight steward of Philippine Airlines. And he was 40 pounds over the desired weight for flight stewards. PAL gave numerous instructions to Iraswege to trim down his weight. That notwithstanding, Iraswege remained over the desired weight for flight stewards based on the existing rules of PAL. Result, Iraswege was dismissed from employment. This case reached all the way up to the Supreme Court. And you know what? Supreme Court said, well, that weight requirement, discriminatory as it may seem, but that is BFOQ, bona fide occupational qualification. Supreme Court said, PAL is not just in transportation area. PAL is also a public carrier, no? And PAL, being a public carrier, is duty-bound to observe extraordinary diligence. Now, it is unthinkable, no? It is unthinkable if PAL would have an employee who is overweight, and what if there is an emergency situation? According to the court, no? Instead of being able to help, no, the passengers exit the plane because of the emergency situation, taking into consideration that the space of aircraft is limited, no? Then it's possible that he may be blocking the way of those passengers. Funny as it may sound, but that kind of discrimination on account of weight was upheld by the Supreme Court. So what is the point here, my friends? The point is simple. While it is a rule that you should not discriminate, but you can have BFOQs or bona fide occupational qualifications. You can make, for instance, age, no, even sex, no, as standards in deciding whether or not you would hire, no, an applicant. For as long as you can make sure that these standards, complying with these standards, is for the furtherance of attaining the objective of the business, and there is no other way by which you can achieve that particular objective other than complying with these standards. Okay? Now, when we talk about the right to hire, we understand that there are companies with duly recognized unions. No? Do you know that one among possible, no, provisions in a CBA? What is a CBA? It's the collective. It's collective bargaining agreement. It is the agreement between the union on one hand and the management, largely pertaining to terms and conditions of employment. Oh, do you know that one among the recognized provisions that a CBA may have is known as union security clause? No? So union security clause may provide that it is necessary for employees to join the union in order for them to stay in their employment. Okay? That is allowed. That is allowed. However, my friends, Supreme Court already said, if there are employees who would not want to join the union of the company, and the reason of the employee for not joining the union is based on religious ground or religious reason, it should prevail over the union security clause. Why? Because in the various constitutional rights, the right to religion is a preferred right. Because according to the Supreme Court, it is a matter of relationship between man and his creator. So it's a preferred right. Okay? So, to be more specific, members of Iglesia ni Cristo are not allowed, no, to join unions. So, if there is a union security clause saying that in order for the employees of this particular company to continue with their employment in the company, they must join the union, otherwise they will be fined. But if the reason why Stephanie, for example, did not join the union is because she is a member of Iglesia ni Cristo and it is not allowed in the religion to join union, then that must be respected. That should prevail over the union security clause. But that is the only exception, huh? So in other words, if, for example, you have a rank and file employee who do not want to join the union and the reason is not premised on religious grounds, then that employee may lose his employment. So this is another scenario wherein a contract, as in the case of CBA, can modify management prerogative, can limit management prerogative. Another right under management prerogative, right to discipline. My friends, it is very important, that when we talk about the right to discipline, you disabuse your mind from what many HR people believe, that if the company doesn't have a company code of conduct, then the company cannot discipline its employees. Wrong. No, I heard a lot of HR people, a lot of HR employees, especially those in family-owned corporations, no, saying, we cannot discipline, no, we cannot yet discipline our erring workers because we do not have a code of conduct. So let us have a code of conduct first. That is wrong. Okay? You have Article 297 of the Labor Code. Article 297 of the Labor Code provides us with the just causes for termination of employment. You have serious misconduct, willful disobedience, gross and habitual neglect of duties, fraud, commission of a crime, no, against the person of the employer or the duly authorized representatives of the employer, and other analogous cases. These are the contents of Article 297 of the Labor Code. You can base your disciplinary action on 297. So no need for a company code of conduct before you can discipline your employees. But if your question is, should we have a company code of conduct? Of course you should have. You should have. But again, absence of a company code of conduct does not deprive you of your power to discipline your employees. Okay? because you have 297 of the Labor Code. But why is it that I'm saying that you must have your own code of conduct? Code of conduct that you did not just lift from the internet or from the code of conduct lent to you by your HR friend from another company. If you want to go to a wedding and you are required to wear a suit, is it not a common scenario that you do not just go to the mall and buy a suit? More often than not, you would go to a tailor, no, to make sure that the suit is tailored fit to you. So same with the company code of conduct. I strongly urge you, if you still do not have in your company a code of conduct, make sure that you should have it the soonest time possible, because having a code of conduct, especially if it is tailored fit to the needs of your company, would greatly help the company, especially in promoting order and harmony in your business. Okay? Now, please take note that when we talk about the right to discipline, it is not only necessary that you must have a reason why you are making this person undergo serving penalty, as in the case of suspension, for example. It is likewise necessary, my friends, that aside from having a reason for the discipline, you must also comply with the procedure, okay, required by law in order for you to discipline your employees. Be sure to comply with the procedural requirement of due process. And the procedural requirement of due process necessitates the observance of the twin notice rule. It is called twin notice rule because you have notice to explain, no? And then you have second notice, which is notice of decision. Okay? Do not forget that. Many HR practitioners would yield to the instruction of the employer. Dismiss Pedro immediately. No need for compliance with procedural due process. Why? Because here is the CCTV footage. Very clear in the CCTV footage that Pedro committed theft of company property. Pedro stole laptop of the general manager. Very clear here on the CCTV footage. Oh, no need for observance of procedural due process. Do not do that. Do not do that. Still, no, comply with the procedural requirements of twin notice rule. Okay? Notice to explain. Then after Pedro explained himself, come up with your notice of decision. Okay? That is very important. Now, take note, my friends, that when we talk about the right to discipline, many HR practitioners believe that when an employee is still on probationary status, he is not yet entitled to the so-called right to security of tenure. Wrong! My friends, even a probationary employee is entitled to the right to security of tenure. What is this right all about? In essence, the right to security of tenure means that you cannot dismiss an employee absent just or authorized cause, and with observance of due process. That is the essence, no, of the right to security of tenure. Now, take note, my friends. This is very important. What does the labor code tell us as regards the duration? As regards the duration of probationary status of employment? Oh, it's 6 months. And Supreme Court interpreted 6 months to mean 180 days. Okay? In essence, law recognizes that not all workers are descendants of Einstein. Oh, what does it mean? Law recognizes that ordinary mortals need time to learn the intricacies of his or her job. And law gives 6 months or 180 days for the person to learn, for the probationary employee to learn the requirements of the job, to fit himself to the culture also of the company. That is why it is wrong for many HR practitioners to just dismiss Pedro, Juan, or Maria, even though they are just 1 month, 2 months, or 3 months in employment, and the reason for the dismissal is this. Well, they're dismissed from employment because of failure to meet regularization standards. Wrong. Because they have 6 months or 180 days to learn the intricacies of the job. Do not forget that. And they have the right to security of tenure, which is coterminous. No, the right to security of tenure is coterminous to the length of their probationary period. Do not forget that. Now, the question is this. Can you dismiss Juan from employment, even though Juan is a probationary employee and just reached 2nd month of employment? Oh, yes, yes. But on account of a just cause or authorized cause, never on account of failure to meet regularization standards. Do not forget that. Insofar as meeting regularization standards is concerned, do not forget, my friends, that the employee, the probationary employee, has 180 days to learn the intricacies of the job. And for the second time, what is the basis? Because the right to security of tenure of a probationary employee is coterminous. Coterminous with the probationary employment period duration. Do not forget that. Now, moving on. Right to transfer. By the way, before we go to right to transfer, let us tackle very quickly the right to for the employer to demote employees. Okay, do not forget that demotion is one among the rights under management prerogative. It is under the right to discipline. Okay, do not forget that. Common mistakes of HR practitioners. Oy, attorney, we have demoted Pedro, ah. You know him, di ba? We have demoted him because of this, because of that, etc. But attorney, we did not touch his salary. So, there is decrease in rank, but his salary remains the same. Wrong. Well, Law allows you if that is what you want. But note that when we talk about demotion, okay, it may carry reduction not just of rank, but also reduction of salary commensurate to the new rank of the employee. Do not forget that, huh? That is very important because many HR practitioners would even reason out and use Article 100 of the Labor Code as their basis, saying, "Ay, attorney, we cannot bring down the salary of one. Why? Because we have Article 100 of the Labor Code. It is the non-diminution rule, telling us that we should not unilaterally decrease the salary of the employee. Oh, that does not apply when we talk about demotion. No, demotion, you can unilaterally decrease the salary of the employee, but make sure that you have accorded the employee his right to due process. Meaning, before he was punished, he must have been heard first. Comply with the twin notice rule. Notice to explain and notice of decision. Do not forget that, huh? Because demotion is in the nature of a penalty. So you have to comply with the due process requirement. Now, opposite of demotion, promotion. Okay. Please take note that promotion is in the nature of a gift. Huh? So since promotion is in the nature of a gift, your intended recipient may refuse to accept promotion. Do not forget that. And you cannot validly discipline that worker on account of his refusal. Now, you would ask, Attorney Alburo, are there really people who do not want to be promoted? Yes. Not many, but there are people who are happy with what they are doing, that they do not want other responsibilities. And so they do not want to be promoted. You have to respect the wishes of a person, of a worker, if that worker doesn't want to be promoted. Do not forget that. Huh? Now, it is at this juncture that I would like to caution you as regards your management prerogative to promote workers. Why? Because I have seen a lot of companies losing a lot of their top caliber salespeople on account of failure to really have a sound grasp of promotion. Concretely, Pedro, he keeps on hitting his quota. Management is very happy. So what did management do? Management promoted Pedro from a sales staff or from a salesman to sales manager. And I'm sure you would agree with me, my friends, that not because Pedro is very good at selling, it does not necessarily mean that if he becomes a manager, he will likewise be an effective sales manager, because that new role necessitates a different skill set, and that is managing people. And I have seen a lot of good workers promoted to leadership positions, like managerial positions, supervisory positions, completely lacking managerial and supervisory skills, lacking leadership skills, and not even willing to learn supervisory and management skills. And they are there, they keep on demonizing their subordinates, causing low morale in the department or section they are leading. So, management ends up firing these people. So be very, very shrewd and exercising your management prerogative to promote. Do not forget that. Let's go to right to transfer. This is my caution to you. Transfer, though it is management prerogative, must not be used to rid the company of an undesirable worker. Do not forget that. Many employers use transfer to rid the company of undesirable workers. Wrong. In fact, if you do that, you expose the company to labor suits, specifically illegal dismissal on account of constructive dismissal. I already told you what constructive dismissal is. Do not forget that. Under our present legal landscape, the purpose for which transfer is allowed, transfer must be for the reason of promoting business exigencies. So it is necessary for the furtherance of the business. That is the reason for transfer. Okay? So if you want to deal with an undesirable employee, especially an employee who keeps on committing infractions, do not use transfer in order for you to rid the company of that particular undesirable employee. Use the disciplinary process. Take note of that. That is extremely important. Okay? Now, management also has the right to set, by the way, when we talk also of transfer, do not forget, this is very important. We are nearing to our end. When you talk about transfer, make sure that the new position of the employee, there is no reduction in terms of rank. There is no reduction in terms of salary and benefits. Do not forget that. If you transfer an employee from one rank to another, or from one position to another, there should be no reduction in terms of rank, salaries, benefits. Do not forget that. If you are going to transfer an employee from one place to another, it must be for the furtherance of the business. Also, as I mentioned, aside from it should be for the furtherance of the business, make sure that your transfer order should be in writing. Because if your transfer order is made verbally and the employee refuses to obey, you cannot discipline that employee on account of insubordination. So make sure that your order of transfer is in writing. Do not forget that. Now, right to set work schedule. Right to set work schedule, this is another right under management prerogative. Okay? So for example, you have an employee who does not want to follow the new schedule ordained by the company. As a general rule, that employee may be disciplined on account of insubordination. Do not forget that. But critical matter that I want to emphasize on you. Article 91B. That is the legal basis of what I'm going to tell you next. If the reason of the employee, why is it? That he wants to be accorded some leeway with regard to the schedule, with regard to the work schedule of the company, is premised on religious ground. Management must respect that. Okay? And the legal basis for that HR is Article 91, Paragraph B of the Labor Code of the Philippines. Another management prerogative, right to reorganize business. Okay? When we say right to reorganize business, so you have the so-called authorized causes for termination of employment, closure, redundancy, retrenchment. These are some of ways by which management may reorganize business. Do not forget, though, that when we talk about retrenchment, the reason for it must be the financial losses. No, company is suffering from financial losses, serious financial losses, or financial losses very, very imminent. Note, my friends, that redundancy is different. When we talk about redundancy, you have more employees than what you only need. And law does not require you to retain the excess number of employees. You may let go those employees that you do not need because they are in excess of what you only need. Another is installation of labor-saving devices. Another is closure. Note, my friends, that when you choose these various ways to reorganize your business, it is subject to payment of separation pay. Okay? Aside from that, you are also required to comply with the twin notice requirement. Different from the twin notice rule that we talked about. Two notices. One notice to the employees to be affected, another notice to the Department of Labor and Employment at least 30 days prior to the effectivity of their separation under authorized cause. Do not forget that. Okay? And again, subject to payment of separation pay. Now, lastly, management prerogative. On management prerogative, management has post-employment restrictions right. Management may formulate non-compete agreements, non-disclosure agreements, even post-training commitments, no? For as long as there is compliance with the law and with the demand of the law for reasonableness. Okay? So with that, it's 5 p.m. now, so I end my talk. So again, this is an abridged version of the rules on management prerogative in order for you to avoid or even win illegal dismissal cases. Thank you.
Thank you, Attorney Alburo. Attorney, that's a very in-depth discussion about management prerogative, and we actually have questions here come from our audience. Here coming from JC. Nowadays, ang mga younger workforce is lipat ng work because of their demands before working. Does having a union in the company a must-have na? Or the question is it best to have a union, to actually establish a union? Or is it high time to retrain management to lead effectively adapting to new forms of working or new norms of working?
I personally believe, subject to the discretion of your management, that problem must not be solved by having a union. Okay? In fact, it is a must that you really study on how to entice your people to stay in your company. You know, it is really very dangerous if you would just put some restrictions in order for your people to stay in their company. You know, the danger of contra gusto. They stay in your company, but they may not really deliver optimally on their jobs.
Yes, it's counterproductive. Attorney, there's a lot of company that there have been questions posted at the Philippines HR group regarding 13th month pay. One is that can the company decide to split the 13th month pay into 2 or 3 gives instead of just giving it on before December 24. They can split it on, let's say, June, or every quarter they would give a portion of the 13th month pay to the employees. Is that something allowed?
Splitting of 13th month pay is allowed by the 13th month pay law itself. But note, my friends, that splitting should only be up to 2 gives only, not beyond 2 gives.
Got it, got it. And then, Attorney, one more question is, there are companies who are paying their employees one time once a month instead of 15th and 30th. Is this something that can be implemented? Is it something allowed by law to just give the salary, let's say, every 30th instead of every 15th and 30th?
Well, that is subject to the so-called autonomy of contracts. No? Management and employees are allowed by law to enter into an agreement. However, I think it is counterproductive because people have certain needs that must be attended to immediately. Then they need resources for that.
Better Rhoda, questions for Attorney Alburo?
Yes, attorney, may question ako. Currently, nagkakaroon noong tinatawag na PEO and EOR, or yung employer on record. So basically, companies in other countries na walang entity here in the Philippines, they will partner with someone who serves as the employer on record, at least as far as Philippine laws are concerned. Is this really allowed by law, or is this more of a gray area kaya nagpo-proliferate siya at this point?
I would say that it is a gray area because there is yet no legislation that effectively addresses the particular matter. However, it is important for us to emphasize that if there will be liabilities, it is the Philippine entity. It is the entity that is registered here in the Philippines, operating here in Philippine soil, that will be held accountable by law.
Okay. So hindi po kumbaga safe yung kung sino man yung kumpanya na nasa ibang bansa. May certain level of safety siya in case of, let's say, labor cases.
That is correct. That is correct. You know why? Because the reason also perhaps why is it that until now there is no legislation to address that matter? Because there is the problem of enforceability. Imagine if you have a company that is based in US and labor arbiter said, "Oi, there is illegal dismissal, you pay back wages," and that company says no. And what if the assets of that company are located in US? No, so there is a problem with regard to enforcement of judgment.
Ayan. Attorney, meron po tayong isang member. Ang tanong po niya, would like to ask for attorney's point of view on the release of final pay 30 days from separation from the company. I think ang question dito is yung 30 days ba starting from the time na nag-resign or starting from the time na na-clear si employee?
Supreme Court is already clear on the matter that clearance really is necessary. No? So you can have it record from the date the employee has been cleared of any and all possible accountabilities with the company. Nevertheless, it is very important for us. Yes.
It supersedes the DOLE advisory, no? Na ni-require ni DOLE na kailangan 30 days upon last day of the employee. Kasi wala silang nilagay doon na clear eh. Ang sinabi lang nila doon, 30 days upon last day, kailangan ma-release yung final pay. But I know that there is existing jurisprudence in Supreme Court that says that kailangan ba-clear muna kasi parang, di ba, kung may accountability pa si employee, bakit siya magpa-final pay?
First, people should really thank you for raising that up. This brings to the table what many perhaps do not know. When we talk about legalities, there is hierarchy.
Correct.
DOLE rules are inferior to jurisprudential pronouncements. So if there is a conflict between Supreme Court decision and Dolly rules, it is Supreme Court decision that will prevail.
Agree.
Ulitin ko yun, sarap ulit-ulitin nun kasi may mga HR na makukulit eh. Supreme Court jurisprudence po susundin natin. Pag merong hindi po nagtutugma, yung Supreme Court jurisprudence po ang may weight. Yung kaso po yan ni Milan versus NLRC.
Milan
Saka
versus
kayo
NLRC.
naghahanap
Yeah,
po kayo.
correct.
Now, also in relation with that, other HR might ask, oh, that's rules between rules and jurisprudence. What if between law and jurisprudence? Which between the two should we follow? Now, when we talk about academic understanding should mean it must be the law. No, it's the law that we must follow. But for practicality reason, it is Supreme Court decision we must follow. Why? Because Supreme Court is the supreme interpreter of the law. So if law says red, Supreme Court said blue. Follow blue, do not follow red.
Agree.
Uy, natutunan ko yan sa paralegal training namin. Supreme Court is the supreme law. So whatever the Supreme Court says is true, that's true.
Plus the fact that
wala ka na pwede pag-questionan eh.
Correct. Saka plus the
Another
fact
application of that, Coach Darwin and Mentor Rona, another application of that. If you're going to read the labor code is very clear as regards the duration of probationary employment status. 6 months. In fact, the word used by the labor code is shall. And our English teachers taught us that shall is a mandatory word. But Supreme Court interpreted it in a different manner. Supreme Court said that notwithstanding, probationary employment status may be extended subject to agreement between the management and the employee. You see? So which between the two you must follow? Supreme Court decision.
Agree. Because, di ba, attorney, if correct me if I'm wrong, any jurisprudence is actually, it becomes a law in per se. It becomes it should be enforceable like the law kasi it's already from the Supreme Court.
Actually, what Coach Darwin is saying is anchored on Article 8 of the Civil Code of the Philippines. Article 8 tells us that Supreme Court decisions have the force and effect of law.
Of the law. Correct. Meron pa rito question, attorney, last two na lang. Does having an ethics committee to every company is a requirement or an option? This is to address judgment on whether they have to terminate or retain employees. Some companies kasi, sir, hindi sila their decision is not brought by management and HR, but they create an ethics committee to resolve disputes and issues.
Well, it is not a requirement. So in other words, it is optional, on the part of the management to have an ethics committee that would pass on disciplinary cases.
Last na lang, attorney, marami rito nagkakamali. Saan yun? Is it illegal dismissal pag a probationary employee was dismissed right there and then without prior advice, without hearing out the employee? I think nasagot yun ito kanina because diba, and probationary and regular employee has the same rights.
Okay. HR listen very carefully, especially those new in the field. It is not enough that you have a reason for dismissing an employee. It is equally necessary that you comply with the procedure required by law before you dismiss an employee. And that procedure necessitates observance of due process. In simple terms, due process requires that you hear first the employee before you punish him. And especially in case of dismissal is considered a supreme penalty. So take note, comply with the twin notice rule. Notice to explain and notice of decision. Question, what if the employee doesn't want to receive the notice to explain? In serving the notice to explain, I strongly suggest, this is not a legal requirement, but this is my suggestion, you must have at least 2 witnesses with you. Let those 2 witnesses with you to sign on the face of the NTE with a notation thereon that when this notice to explain was being served to Mr. Juan de la Cruz on 24 September 2023 at around 4 p.m., he refused to receive it. Signed, Maria de la Cruz, Pedro Reyes as witnesses. Okay? And then if he does not want to give the company his written explanation, so be it. No, the right to due process is a right that can be waived by the employee. Do not forget that, my friends. And do not stop there. Do not stop there. If you think that the explanation of the employee is lousy, no, like for example, the employee simply said, "I did not do it," and then he just signed it. Still, proceed with the second notice, which is the notice of decision. And on the notice of decision, you put there the facts and circumstances which led you to decide that this employee is really culpable, that he really committed the infraction, and he must be penalized according to the code of conduct, stating therein the penalty.
Agree. Attorney, one last na lang kasi ito yung pinakamait na topic ngayong linggong to. Is hiring AI, artificial intelligence, ethical? Since hiring AI actually is non-person, non-organic, which cannot be bounded by labor code or our labor law. But GMA7 just put their newscasters in AI as their new newscaster. This is something ethical daw.
Okay. My take on that is this. First, before I answer the question directly, is it legal? Anything that is not illegal is legal. Okay? That is the rule. Now, there is no law that prohibits that, hence that is not illegal. Is it ethical? Well, my personal view is any work, any task that necessitates exercise of discretion, and that exercise of discretion would affect other people, and the exercise of discretion necessitates compassion, for instance. A machine cannot exercise compassion. So those are my parameters, no? So that's just personal to me, and you may perhaps use that if you want, no, in order to decide for yourself whether it's really ethical or not. But in terms of legality, it's legal.
Thank you for that, Attorney Alburo. You have provided us with a lot of in-depth information and more understanding about labor's law today for this particular episode of HR Cafe. Attorney, how can companies reach out to you if they would like to hire your firm or if would like to get your services, or if you have, alam ko po may mga seminars din po kayo, di ba, Attorney Alburo? How I would like to give you this opportunity to please invite our audience, our community. How can they reach out to you? How can they reach your firm? And what are the activities or programs that you have?
So thank you for that, Coach Darwin. We are Alburo and Associates Law Offices. All the contact details you can search in the internet, no. But what is very important for me, aside from that, is for those HR practitioners who want to advance, no, in your field. I strongly suggest that you consider seriously enrolling in UP Soler. Coach Darwin has a certification from UP Soler.
Even Rona.
Even Mentor Rona. So HR, no, is becoming a lucrative field, no. That's why you must consider that very seriously. But those who want, those who need our legal assistance, our firm, you can find the contact details in our website. That's
Alburo and Alburo Law Office, di ba, Attorney?
Yes.
Okay. And any seminars or programs that you have scheduled before the end of the year? Or yung sa UP Soler po, paano sila makakapag-enroll?
For UP Soler, I believe that an employee of UP Soler is also a member of Philippine HR Group. Mr. Jack Valenzuela, shout out. to Jack Valenzuela. So you contact Mr. Jack Valenzuela or you just call UP Soler, no? The numbers you can find in the internet.
Okay. Again, maraming salamat po, Atty. Alvin, Liao, Alburo. Thank you for providing us with, again, your experience and your knowledge with regards to labor law. Patuloy po kaming, kumbaga, we're very grateful for having you today. And at salamat po, hindi nyo kami hindian at patuloy nyo kung sinusuportahan ng Philippine HR Group at HR Cafe.
Very, very much welcome. You are very much welcome, Coach Darwin, Mentor Rona, and the Philippine HR Group as a whole. Very much welcome.
Maraming salamat po. Mentor Rona, would you like to close the show for today?
Yes, naku, napaka-inspiring po ng ating talk for today. Konting-konti na lang, attorney, maglolo na rin ako. Oo. Pagkatapos ko yung paralegal training ko, idediretso ko na ng law.
Oo nga, di ba? Magtitake ka ng paralegal training sa Soler din, right?
Sa UP din. UP, sa College of Law. Pero ano na siya, ongoing na siya actually. Kinakabahan ako dahil meron kami exam sa Monday. Pero sa mga gustong mag-ano dyan ha, mga gustong talagang mag-focus sa law in general, hindi lang sa labor law. Naku, sinasuggest ko po sa inyo, itry nyo yung paralegal training ng UP College of Law kasi marami kayong matututunan. And then later on, pwede kayong mag-focus doon sa paralegal training for labor law. Ang dami kong natututunan. Nasa first week pa lang kami, pero super na-appreciate ko yung course. At dyan po nagtatapos sa isa na namang linggo. Yes po.
Mentor Rona, no? Pahabol. I stand corrected as regards one of the questions proffered by Coach Darwin. You have Article 103, no, of the Labor Code. Under Article 103 of the Labor Code, the payment of wages, the payment of salaries must be at least twice a month. So for companies who want to pay salaries only once a month, do not do that. Okay? Follow Article 103 of the Labor Code, at least twice a month.
Ayan
Salamat po,
so,
Atty. Alvin.
Thank you, attorney, sa mga HR po dyan, ha? Twice a month po. Naku, marami akong mga kilalang company.
Pinagalingan ko nga, one lang.
Ako din eh. Ayan. So, twice a month po, mga kapatid na HR, para hindi po tayo sumabit sa batas. At, tulad nga ng aking sinasabi kanina, dyan po nagtatapos ng isa na naman pong napakagandang usapan dito sa HR Cafe, usapang trabaho, buhay at iba pa. Huwag pong kalimutan na kayo po ay mag-register para po sa ating upcoming Philippines HR Group Summit para makakuha din po kayo ng access sa ating World HR Summit. Malapit na po yan next week if I'm not mistaken. At kung kayo naman po ay gusto nyo po mag-sponsor or maging sponsor para sa Philippines HR Summit, huwag pong kalimutan na mag-reach out po sa kahit na sino pong member po ng board ng Philippines HR Group at pwede rin po kayo mag-email kay darwinreverse@yahoo.com or mag-message po kayo sa page po ng HR Cafe or mag-reach out po sa kahit na sinong admin or moderator ng Philippines HR Group. Magkita-kita po tayo sa HR Summit. Huwag niyo pong kakalimutan yan dahil ang tagal po bago ulit natin nagawa ito. So, dahil sa pandemic, ngayon na lang po ulit tayo maaaring magkita-kita. Makikita nyo in person ang ating mga naging guest na speaker dito sa HR Cafe, ang ating po mga mentors, moderators, admin ng HR, ng Philippines HR Group at higit sa lahat po ang Board of Directors ng Philippines HR Group. Muli maraming salamat. Enjoy your Sunday everyone and we'll see you next week para sa isa na naman po makabuluhang balitaktakan dito po sa HR Cafe, usapang trabaho, buhay at iba pa. Happy Sunday everyone. Enjoy your rest day po. Monday na naman bukas. God bless. Bye everyone.
Atty. Alvin, salamat po.